Professor Martin.
Thank you very much, Mr. Chairman. My prepared testimony addresses several questions concerning the use of immigration powers. In the interest of time, I will not address those here in my oral statement, but I'll focus on the final topic addressed there, and that is this. The administration has asserted broad authority to detain persons indefinitely if the executive branch deems them to be enemy combatants or unlawful combatants in the war against terrorism. This practice began with persons picked up in the combat areas of Afghanistan, over 600 of whom have been transferred to the U.S. Naval Base at Guantanamo. Nearly all of these are aliens of many different nationalities. One of them, however, named Hamdi, was discovered to have been born in the United States and so to have U.S. citizenship. He was thereupon brought to the United States but remained under a strict detention regime. The reach of the enemy combatant doctrine was then considerably expanded when a U.S. citizen named Padilla was picked up, not in a combat area, but at O'Hare Airport. He was soon declared an enemy combatant and has been held incommunicado in a military prison ever since. The government has also picked up one non-citizen in the United States and held him under similar conditions. The government asserts the authority to hold such enemy combatants under the law of war until the end of hostilities, apparently meaning the war against terrorism, whose end, of course, is not anticipated for a very long time. The government has strongly resisted court review of such detentions, or failing that, has argued for an extraordinarily deferential standard of review. Moreover, it has asserted the authority to hold such persons virtually incommunicado as part of a stress and duress interrogation regime meant to break down the person's resistance to providing information the interrogator seeks. It has fought hard to prevent court-ordered access to counsel for Padilla or Hamdi, although just last week the Defense Department decided to extend that privilege to Hamdi as a matter of grace and not of right. Furthermore, the President made a controversial blanket determination that all of these enemy combatant prisoners at Guantanamo, even Taliban fighters, were not entitled to prisoner of war status under the Third Geneva Convention. The government eventually did say it would provide core protections to them, but the core evidently does not include the treaty's explicit ban on coercive interrogation. Now, the government to date has prevailed in the Guantanamo cases in its view that no court has jurisdiction to consider habeas corpus there. But just a few weeks ago, the Supreme Court accepted a Guantanamo case to consider precisely this question. Lower court decisions in the citizen cases, in contrast, have recognized jurisdiction in habeas corpus, but have applied highly deferential standards of review. Now, what should we make of this practice? In my view, what is objectionable here is not the underlying idea that the law of war should be applied in some fashion to our struggle against terrorism after September 11th. I agree with that. What's objectionable is rather the extraordinary sweep of the government's asserted powers with regard to those labeled enemy combatants. We must now go beyond the law enforcement model. I agree with that. A model that structured our anti-terrorist efforts before September 11th because of the scale of the threat that we face. We should find ways to use the wide range of tools that a state of war brings into being. But there must be limits. The most important tools for present purposes are two. First, war allows preventive detention of captured combatants without any need to prove criminal charges. Secondly, war privileges certain acts that would be considered murder or assault under other circumstances. We can target al-Qaeda members without any need for warrants, indictments, trials, or sentences. The key point, however, is that war brings into play a different set of rules, not the absence of rules altogether. The world community has gone through a painful evolutionary process over the past 100 years and more to try to refine the laws of war so as to avoid indiscriminate cruelties. The United States has participated actively in this development, and U.S. military lawyers have been among the leaders in asserting the importance of these humanitarian limits. The protections that are most relevant here are, first, the safeguards of the Third Geneva Convention applicable to prisoners of war throughout their detention, including important minimum standards for conditions of confinement. And secondly, rules requiring that privileged violence be directed only at military targets and adversary combatants, carefully distinguishing civilians to the greatest extent possible. This is often called the principle of distinction. Unfortunately, the executive branch in our current struggle appears to want the added powers that would come with treating the anti-terrorist struggle under the law of war, but without most of these hard-won restrictions or protections, even in some form, and I emphasize this, even in some form appropriately modified to take account of the different character of this conflict. That's a highly worrisome development, powers without protections. What we badly need now is a serious effort to wrestle with how to adapt the laws of war to the new kind of conflict we face, but to modify them in a way that still balances powers and protections. This will not be easy by any means, and it will surely be controversial, whatever framework is developed. But the executive branch, in my view, should have taken the lead in trying to spell out such a new framework, probably in the form of legislative proposals that could receive full debate and consideration before Congress. That opportunity has so far been missed, but it is possible that the Supreme Court's decision in the Guantanamo case will help induce Congress to take up that issue. In my view, the Guantanamo detainees should presumptively be given the full range of protections set forth in the Geneva Conventions for POWs until we work out an appropriate, more limited regime. I say this because I am quite concerned, as has been the International Committee of the Red Cross, which has visited prisoners there, about the current conditions of their confinement. In addition, in order to honor the principle of distinction, we should offer an early opportunity for detainees to demonstrate that they had nothing to do with terrorist acts. That is, to show that they're basically innocent civilians. Applying these protections does not immunize detainees from punishment for their own crimes or violations of the laws of war. That's a highly important point. But punishment should occur only after a trial in which they're given a reasonable opportunity to defend themselves. Trial by military commission could be suitable for these purposes, but we must strive to make their procedures conform to the protections set forth in the Geneva Conventions. The Padilla detention involving a citizen picked up on U.S. territory is far more chilling. The government's arguments supporting his indefinite confinement give little sense at all of how profound a line is being crossed in that case. If Padilla can be held as the government asserts, we are all vulnerable to indefinite detention without any access to counsel or even to family on the mere say-so of an executive official. This is not a question of current good faith. This is a question of the kinds of powers that are being made available and asserted. The Supreme Court, in my view, should swiftly declare that particular detention unconstitutional. In conclusion, Mr. Chairman, members of the Commission, we suffered a terrible blow on September 11th, but it must not be allowed to obliterate the accumulated learning of centuries, dating all the way back to Magna Carta, about the dangers of unchecked executive detention authority, or about the need to observe humanitarian boundaries even as we wage an armed conflict against a new and ruthless enemy.